Hi, folks. Tim Forshey here once again. I've been getting a lot of questions about NFA Trust. Not surprising in light of the new rules that were just put into effect by the ATF about pistol braces. They're more popular than ever. People are understanding the benefits of NFA Trust. But it seems like I get a lot of the same questions over and over. So we thought we'd address some commonly asked, I guess we call those frequently asked questions, FAQs, so that maybe we can save you guys some time if you decide you want to do an NFA Trust. So with regard to some of the questions, first of all, the sweeping changes that ATF initiated back in 2018 with regard to responsible persons. It used to be that anybody listed in the trust had access to the firearms. Now that's not true. Now anybody who is designated as any kind of trustee at all has to be designated as a responsible person. Responsible persons have to submit fingerprints, photographs, sign some forms. No big deal, but it's something that you need to consider when you're setting up your trust. Basically, the only people that aren't responsible persons are generally going to be the beneficiaries. And we'll get to that in just a second. But understanding who the responsible persons are, and don't forget, a trust is a legal document that you use when you don't have that for someone. In other words, when you don't trust somebody, that's when you probably want to trust. The best rule of thumb I can give you is you don't want to list anybody as a responsible person on your trust unless you really, really trust them. A spouse, a very devoted life partner, a child, a brother, a sister. These are the kinds of people that we normally trust with life or death decisions. When you list somebody as a responsible person on your trust, they have full access, right, and responsibility to all the items in the trust. They could literally sell your machine gun without even notifying you that they had done so, and it would be completely legal. So make sure you understand who you're listing on your trust. That's a very big piece of advice. So once you decide who your responsible persons are going to be, then you want to designate them as either the grantor trustee. That's going to be you. The person who would be owning the items if you were doing it personally would generally be the grantor trustee. That's one party, grantor / trustee. Then you're going to talk about co-trustees. I would usually recommend, if you're married, that your spouse be a co-trustee. Long-term life partner would be a co-trustee. Maybe somebody that you share a residence with, brother, sister, children that are of adult age, over the age of 21. These are the kinds of folks that you want to list as co-trustees. You get the maximum benefit from your trust by listing those folks as co-trustees. Then the next category is what we call successor trustees. If the grantor trustee and the co-trustees are unable to serve for any reason, usually that would be death, then the successor trustee would step up. I've never been a huge fan of successor trustees. I just don't really see what they do. I'm list a couple of co-trustees, and I don't think you're ever going to probably get down to the bottom of the bullpen to need the successor trustee. But there's folks that want to wear belt and suspenders, so they want to list a successor trustee. Then there's even an alternate successor trustee for people that really want to wear a belt and suspenders and have their pants sewn onto their hips. They want to probably have an alternate successor trustee as well. So, and then last but not least, we also have beneficiaries. I would usually recommend that beneficiaries are going to be minor children, people below the age of 21, that you do want to have a testamentary interest in your item. So after you pass away, so you want to list them as beneficiaries. I would tend to think of beneficiaries as future co-trustees, as a co-trustee in training, if you will. I usually recommend to people that once your minor child reaches the age of 21, if they're living in the same house, particularly if they're interested in your shooting hobby, you probably want to list them at that time as a co-trustee. Which brings up the next point. You don't ever want to redo your trust as a new trust. You want to amend your existing trust. You want to keep the same title, the same date of establishment of the trust. That's the only smart way to do it. But you don't ever start over and do a new trust. If you do that, you have to transfer the items from Trust A, then into Trust B. A lot of hassle, a lot of paperwork, and $200 per item. Next thing that seems to come up a lot is how to name the trust. And people tend to try to make this too simple, I think. I don't understand why. A lot of people want to call it the Joe Smith Trust. I'm not really sure why you want to make it that simple. Don't forget, this has to be a definitive trust. It has to be a delineable trust. If it's the same as 10 other trusts, the ATF's not going to approve it. Theoretically, if it's the same as one other trust, the ATF's not going to approve it. So, if you have a very common name, you might want to jazz it up a little bit. Call it the Joe Smith Arizona National Firearms Act Revocable Trust, something like that, just to make it a little bit more definitive. That way, there's a way less likelihood of it getting rejected. I've had a few clients that had to rename their trust, and it caused a delay in the process. So don't forget that. I do recommend that you tack on National Firearms Act Revocable Trust at the end of the trust. A lot of people just want to keep it simple, and the only reason that people have ever given as for why they want to keep it simple is because it makes the engraving process, when you do a Form 1, usually that's going to be a short barrel rifle, or if you are making your own suppressors, there are kits out there to allow that now. If you're going to do a Form 1, then you're required to put the manufacturer of the item on the item itself via engraving. Generally speaking, that's going to be something that you're going to farm that out. Most of you probably don't have your own laser engravers. It's not a big deal. Most of the engraving guys that I know don't charge by the letter or the inch. They just charge by the job. So it's going to cost 30, 40 bucks regardless of how many words are in it. So I would strongly suggest that you give the full name of the trust and do it appropriately. So mine's called the Timothy A. Forshey National Firearms Act Revocable Trust. I always like National Firearms Act Revocable Trust because the acronym for that, of course, is NFART. And that always kind of makes me giggle. I don't know about you guys. One of the next questions that I often get are, I want to have some of my responsible persons who live out of state. Is that okay? The answer is, of course, it's okay. No problem. They can even live in a particularly anti-gun state that doesn't even recognize Title II rights, such as California or Illinois. And that's fine as well. However, there will be some logistical difficulties, not impossibilities, but difficulties. They do have to submit a photograph. They do have to submit fingerprints. They have to fill out the 5320 form. That's logistically difficult if they're in a state that doesn't even really recognize that right. So sometimes they might have to go to an adjoining state. Folks in California might have to cross the border to Indiana. Folks in California might have to cross the border into Arizona in order to find a Class 3 dealer who can actually help you do that stuff. But as long as they live in one of the 43 states that are Title II friendly, shouldn't be any problem at all. They can go to any Class 3 dealer. They probably have a silencer shop kiosk located in the store, and you can literally upload the fingerprints, the photograph, and the forms electronically in just a few minutes. It's not a big deal at all. So don't be worried about having out-of-state responsible persons. It's perfectly easy and fine to deal with that. A lot of folks then say, I'm not really trying to save money so much, but I just want to make it simpler. I already have an existing family trust. Can I just merge my NFA trust with that? Can you just add that in there? The answer is no. And don't forget, that's a very important point. Family trusts are done for estate planning purposes, and they're fantastic. They allow you to avoid probate. Probate can cost thousands of dollars. That can take years to get through probate court. If you can avoid probate court, you definitely want to do that. And a living trust is a fantastic estate planning tool to do that. An NFA trust is literally simply for the ownership and acquisition of Class 3 firearms. That's all it is. So make sure you understand that. And you can't really merge those. If you think about it this way, if you did merge them, and somebody who's not designated as a responsible person, who hasn't jumped through the proper federal hoops in order to take possession of one of the items, is listed in your family trust, that's now an illegal document. It's an illegal trust. You're trying to transfer property that can't be transferred like that. It's like if a pharmacist has a license that allows them to deal with narcotics and they die, that doesn't mean that their kids or their wife can take possession of those narcotics. They're very tightly controlled items, just like Title II firearms. So be aware of that. You can't merge those two items. So don't forget, guys, National Firearms Act trusts are very much alive and well, and they're a really great tool to help solve a lot of problems. We've covered those in videos elsewhere, but just wanted to cover some of the FAQs today that seem to come up a lot. So if you like what you heard today, go ahead and like or subscribe down at the bottom of the page. Again, please submit anything that you'd like us to cover in these videos in the future, because we're looking for content and we want to make sure it's content that you guys like. Thanks for tuning in, and stay safe.